So our next session is being put on by the representatives of the Law Society, Unlocking, Unbundling, and Practice Opportunities. I feel like I'm in one of Nathan's tests when I try to say that. We have Cara-Marie O'Hagan next to me. She's the Executive Director of Policy at the Law Society. And I'm sure many of you know Sheena Weir. She's the Executive Director at the Law Society, including External Relations and Communications. I was shocked to learn that she's been with the Law Society for nearly 23 years. So she must have started when she was about 7. Sheena has been a wonderful resource to us at FOLA, and she's attended many, if not all, I don't know all, but many of our plenaries, and we have enjoyed the dialogue that we have with her and other members of the Law Society. And today they are going to put us to a little bit of work because this is intended as a dialogue and a bit of a working session. So I will hand it over to Cara. Or Sheena's going first? Okay, sorry.
No problem. I was going to just introduce the session a little bit, as well as my colleague. Cara's joined the Law Society. She's been at the Law Society in the past, so she knows us well. She knows your organization well, but she's been in this position as the Executive Director of Policy for almost a year now, and she's doing a fantastic job. As all of you that do know me, you know that I'm very, very dedicated and committed to engagement and outreach, and I can assure you that so too is Cara. So we were knocking our heads around a little bit about getting some feedback, and we thought that FOLA was an obvious and good place to start to do a little bit of engagement. We're experimenting a bit, so we'd love to have your feedback after. Both of us are hanging around. We'll be here until tomorrow. So we'd love to have your feedback if this was a good way of getting some information. But we really would like it to be interactive. Cara's going to introduce a little bit the topic and what we're hoping to do, but then we, as Bill said, we're going to make you do some work and then come back together and hear back as to what we can be doing in terms of our policy development process, making sure that we're hearing from you. So with that, is that enough of an intro, Cara?
That's extremely, extremely kind, Sheena. I owe you big time. So
I'll collect.
As Sheena said, we are really here. Can everyone hear me? Yeah, we're here to hear from you about some of our initiatives with respect to access to justice. As you know, the Law Society has a statutory duty to facilitate access to justice, and with respect to this responsibility, it's something that essentially we have to do in partnership with the bar. Otherwise, there is no justice to be facilitated. So I'm here today to talk about 4 initiatives that we have, I guess facilitated would be the right word, with respect to the access to justice at the Law Society. It is the Law Society Referral Service, what I think we're calling flexible legal fees, but that really is what you do in your practices to give your clients a break when they are high needs or there's special circumstances or there's other issues at play. Limited scope retainers, which we sometimes refer to as unbundling, and legal coaching. So I'm going to put a list of those on the board in a minute. What I'd like us to do, or I'd like you to do, if you could, within your tables, or maybe if you wanted to get together in slightly bigger tables, if that works as well, to talk about 2 of those initiatives at a time. I thought we'd talk first about unbundling and legal coaching. I'd like to know from you if you do it, or if your firm does it, or your partners do it. If you do it, why? If you don't do it, why not? What works about these initiatives, what doesn't work about the initiatives, and what we can do to help with respect to those initiatives. The other 2 are a little bit more amorphous in terms of the participation, but we'd also like to know the same things with respect to the Law Society Referral Service, and also what you do about billing and how you make decisions about when you're going to give clients a break, and if you feel comfortable talking about that or advertising that, or let that be known. I think we feel that there's a lot of good work that's being done by the bar that we don't always know about and we should know about. So I'm hoping that this is going to be a start. So I can, if you wish, go through those initiatives and talk about them a little bit, but I have a feeling that you're all pretty familiar with them. You can let me know. Do you want me to explain what those things are? Is that a yes, a no? Well, at least I'll put the list up.
Somebody with a,
I would like to know limited scope retainers. I mean, I guess it's the answer to the question. I obviously don't do it because I don't know what it is.
Okay. All right. Well, here is the list. So the Law Society Referral Service, I think you're fairly familiar with that. That will, clients can access 30 minutes of consultation and legal information, and lawyers pay a fee to belong to the service, and then the clients are referred to the lawyer. Okay. Flexible legal fees, I think you have a better idea what that is than I do, actually. Unbundling or limited scope retainers. So this is a when instead of having the full service, you know, from the initial meeting to the statement of claim to the trial to the judgment, et cetera, there is an agreement, a written agreement, to provide a certain set of services. That could be preparing motion materials, for example, and then the client will go into court and argue the motion himself or herself, or doing some kind of interlocutory application, or not doing the negotiation, for example, on an agreement, but then drafting the agreement itself. So it's a variety of services that are limited in scope. And then legal coaching is a subset of that. It's the same kind of thing. You do provide a limited set of services. It's not a full service on the file. I think the primary difference there, and they are sometimes intermingled, is the idea is that there's a lot of guidance and coaching for the client himself or herself, so that they can deal with the situation themselves, deal with the, you know, be in argue a motion, be in a case conference, negotiate something. That's the general idea of that. And I think these are the questions in general with respect to each one of these. Do you do it? Why or why not? What are the benefits? What are the difficulties with them? And what could we do to help? Any questions about any of that?
just in terms of breaking up too, I know that you do this for your regional tables all the time, so I know that we can sort of shift at least say into 4 groups to sort of have some discussion, just pull some tables around, because we're going to do what, 10 minutes, Cara?
Yeah.
And then Cara and I and Aaron is here too, is going to wander around a bit. So if everybody in that group could sort of take a few notes, we'll try and get around and hear everything firsthand, but we'd like to have it repeated back to us as well for the benefit of the whole group in case we've missed anything. Does that make sense, Cara?
Yeah, absolutely. I saw a question there. Was there a question? Terry?
Terry.
I had a question. It's just about this unbundling.
Yes.
And in a criminal law practice, I hear what you're saying about contracts and this and that. Can a lawyer under the amended rules of professional conduct, thank you, can a lawyer under the amended rules agree with the client, for instance, to take a matter through a preliminary hearing and to the conclusion, and then if they're committed to the Superior Court of Justice, the retainer ends, and then if they choose to have you continue on, then they need to come up with an additional retainer, because they may very well not be committed at the conclusion of the preliminary hearing. I tried to do it, and I had a judge tell me, you can't do that. You can't say you have a limited retainer you're on the record or you're not on the record. And I said, well, I am engaged, but only to go this far. So I'm wondering where we stand today.
So I am not the expert on how all this works in the practice management helpline. I'm sorry about that, but I hear your point. Was this a fairly recent thing that happened?
Within the last 2 years.
Okay. Thank you.
But I think one of the things that we're hoping to hear, Terry, is actually things like that,
Yeah.
that these are our challenges. One of the things, for example, that we hear from Tammy Moscow, who's busy working on getting unbundled things together, is she said that there's been a lot of education of the judiciary to understand that in family this is so important and here's why. And so it's partly hearing about where the challenges are so that we can talk to our colleagues in the judiciary offices and get the information going. And that's why we're here, really, is to hear about the challenges as well as how things that are working well. So we can't give you the legal help necessarily, but we can sure hear about it so that we have the right rules in place and the right conversations so that judges are used to having this. Because, I mean, that happened a lot. Those of you that are doing family law know that happened a lot, right? That you go in to do a little bit to help somebody out, and all of a sudden you're on the record for free, right? Yeah, when you'd already done a bunch of free work before you got there? Yeah. So let's hear about the challenges. Are things changing? We'd love to just know what's going on that front. So does that, any other questions before we make you work first with moving and then writing and talking and we'll wander around? Is that all right? Maybe 4 groups, one over here, one kind of here, and in the back. How's that? Okay.
And just to remind you, I think we'll do numbers 3 and 4 first. 3 and 4.
So we're going to talk about 3 and 4. Unbundling of legal services and legal coaching.
Is everybody, are the discussions pretty much concluded? Okay.
Well, the good news is I heard there's a lot of unanimity. So, once we start reporting back, if you've heard it at one table, we don't have to hear it at another. So we know you'll self-select.
Yeah. Now, I saw somebody stand up over there, so I'm inviting you to go first.
Here, why don't you? Okay, there we go.
Okay, I think we're ready.
Okay, so we seem to have a mix of practice areas at this table, but I think it's generally recognized that the limited scope retainer is probably is suited to family law, but not other areas of practice. As far as coaching goes, I think it doesn't seem that any of us have been seriously involved with that, and there's a real concern about the risk involved in coaching, and that we have really no control over what the client says after the coaching session is over. As far as the unbundling of services or limited scope retainers, the big issue is if you're the lawyer on the other side and you've got an unrepresented on the other side of the case who some of the times is using a lawyer, some of the times isn't. It becomes a real issue as to who you're dealing with, and practical issues such as service issues, especially if you're approaching a trial and there's some short time frames. Do you serve the lawyer? Do you serve the client or the unrepresented party? Do you serve both of them? If you have to serve the unrepresented party, is it like a 5-day service if you mail it because you might not have a fax number or even an email address. So you get into those practical issues. So I think basically the consensus here was if a client on a limited scope retainer needs a brief or something like that, or maybe assistance with pleadings, we'd help, but other than that, probably not.
So, yep, we had a mix of practices at this table as well, but a lot of consensus, really. It's kind of interesting. We sort of came down on the side of coaching being cost-effective for the clients and unbundling not so much. We did hit on the same point that the previous table next to us did, and that is that it's a different kettle of fish for crim versus family, where the family files and the civil files, we've got documents that are going across the counter at the court, and they've got our name on them, or they don't have our name on them. We're either in the game or we're not in the game, whereas for the crim lawyers, they don't have those documents going across that clearly label them as being on the record, but if they show up enough times and try to get away with calling themselves an agent, sometimes the agent part just gets dropped off of the endorsement and they're on the record whether they like it or not. Yep. Okay. And then, of course, the background piece, even for the lawyers in either family or crim, is that it's pretty obvious when you've got a self-represented in front of you that there's been a lawyer that's drafted the documents. And so some of the judges sometimes will just, when they hit a wall with a client, demand to know who the lawyer was that drafted the material. And when woe to the lawyer if they're standing outside in the hallway when that discussion goes on with the judge. Because, yeah, you get called in and it just gets deeper and darker at that point. We also waded into the referral service and the flexible legal fees. You want me to go on that? Okay. Again, fairly unanimous at this table. We thought that the lawyer's referral service was useless. Really not useful at all. Mostly a waste of time. Clients would, first of all, the lawyer's paying up front to have the privilege of having people come in and take up quantities of time that don't fit into half an hour, first of all. My practice is a family law practice. I can't get enough information out of people in a half an hour to do anything useful for them. And so it ends up morphing into a bigger package of time than that. And then the clients really hit the jackpot, and I'm really behind the of my bottom line. So I have a different process than lawyer referral service. If anybody wants to know about it, come and see me in Hospitality Suite and I'll give you the lowdown.
Tell us now. We want to hear about it, Jane.
Sorry.
As long as it's on the books, like, you know.
Yeah. Oh no, there's no.
Sometimes I don't want to know everything.
So I apologize to everybody at my table because I already went through this. So here's what we do in my office, and it's scripted. So my staff who answers the phone, they actually have a script in front of them, and it goes something like this. Jane's hourly rate is blah, blah, blah. When you come for this initial intake, you're expected to come prepared to pay for 2 hours, and staff will give them the full to-the-penny number that's going to amount to. So they're expected to bring X number of dollars, which includes the tax. They're also told that they will only pay for the amount of time that we actually spend together. And then they're told that then they're told my retainer, my full-on retainer is Y. And if they come back after that initial consultation and bring in the full retainer, I will then credit them back for some period of time free legal advice. Staff will only ever tell them that it's half an hour, but I very often will carve it out to be an hour. And so that's how, over time, I've gotten away from the lawyer referral service, because I found it was just a recipe for disaster. And I always came away with a really bad feeling. And I was doing it before there was a price for me to buy into it. When that happened, that was the death knell in my office. I was, no way I was doing that. And then flexible legal fees, again, consensus around the table, lots of different ways of doing it, but basically we all do it. And we all do it on our own criteria, which mostly boils down to how we get along with the client, what we think the client's needs and means are. So again, just a very personal, we're connected with our communities, and we do what we have to do for our communities.
Thanks, Jane.
Sorry, can I just ask one question about the first thing you said, Jane? You were saying that you thought coaching was cost-effective for the client, but unbundling less so?
Yes.
Could you just elaborate a little bit on that?
Do you want to elaborate on that, John? That was your...
Thank you. The coaching is usually a unique process where the person comes in with a particular set of circumstances, whether it's I've just been served with a statement of claim, what do I do? And it's a lot easier for you to say, well, the rules of civil procedure require you to do a defense in such and such a time, this is what you can do, this is the format, this is how it is, etc. Done, the service has been completed, you render an account and they're done. Now, again, there's letters that can be provided to people to make sure that they understand the scope of what you are doing so they have no expectations going further. When you do unbundled services, typically, at least in my experience, it was death by 1,000 cuts. The client thinks that they're getting a bargain, but in fact, because they're coming back 30 times to do something that you could have done in 2 steps instead of 30, they end up paying 30 times more than they should. And then that then leads you to certain problems, their expectations perhaps, and perhaps even issues with the Law Society. So we said that when you came forward and said, what can we do to help? Well, if unbundled services are what you would like to see ultimately, then if you created the letter or the retainer letter or the release or whatever form that we can find on the website that will give us the comfort to know that we have complied with all your requirements and that is clear to the clients, then I think it's an easier sell. But that was the rationale.
Okay, thank you.
That's a tough one to follow. You nailed it. At our table, we have 5 individuals who say they do some limited unbundled work. One who says, absolutely not, I never would. So we went to the why not. And the response was, because you're not properly serving the client. It delays the administration of justice. For instance, in a family court case, you, let's say, do the documents, the person goes to court, then they come back and now they want you to help them with an affidavit, but they report back to you because they are a poor historian that the judge said this, that, and the other thing. Meanwhile, the judge said quite the opposite. And next thing you know, you're going in a direction based on what the client's instructing you, which isn't the direction you should have been going at all. Also, in terms of negatives, we discussed that it's okay to do this if you're very, very selective. With many clients, it's not going exactly as you were saying. It's not going to save the client any money because they're going to keep coming back. And if you had simply followed through right from the beginning, it would have been better. Overall, it appears to be a disservice because there's a need for a lot of corrections of mistakes within the work. On the positive side, for the lawyers that is it was said by one, basically you have piecemeal work, which is better to have some work than no work at all. Benefits to the client would be that the client now has peace of mind. At least they have a lawyer who's able to speak with them. Some of the counsel here suggests that the legal aid staff lawyers are not necessarily able to have the continuity to carry through, and at some point they can no longer assist. So for the client to be able to know they can engage someone for a limited time frame at least, it's better than nothing. It also helps to focus the client's mind in order to move forward, and guidance is good, was how that was summed up. In terms of impediments, as I had raised earlier, we summed it up that the judges need to accept that you are not permanently on the record. If the court is not going to see this, then it's not beneficial to anyone involved because it's going to cause problems. And another impediment we summed up is a real risk to your reputation, because you may give advice and you may have given very good advice, and then that client goes to the courtroom where you are not present and turns around in front of your colleagues, and more significantly to the judiciary, and indicates that you gave such and such advice, which you never ever said. Somehow they've heard only what they wanted to hear, and there's a complete breakdown in communication. That's your reputation. In order to protect yourself from that, we discussed the need for reporting letters, and those letters would have to be very thorough, and that's a great deal of work, and now you've eaten up all the time. So in short, to have a supportive judiciary would help. For the last question, reporting letters would help, especially if someone goes to one lawyer and then goes to a different letter, if you could see those. And if you're doing litigation, to be able to receive the endorsements so you could properly advise the person would be helpful. Thank you.
Great.
Anybody else have any other comments that have not already been made? Bueller? Anyone? Yes.
It's along a similar theme, I think, to the comments you've already heard, but as a group, I think we were somewhat skeptical of unbundling and coaching because of the difficulties that one might not foresee at the start. One of which was pointed out is that coaching often leads to delays in the system. Because client comes in to see me, I give that client my coaching advice, they go off to their court proceeding, and in the middle of the court proceeding they say, well, Mr. Horner told me this and this and this, and now that I've been in court, I want to go talk to Mr. Horner again. So instead of the matter being resolved that day, it gets adjourned because that client wants to go back and consult with their quote-unquote counsel or lawyer. And I can see that happening repeatedly, and the judiciary being uninclined to say to the client, well, look, you had your advice, you're here now, make a decision. They'll get that time, and that wastes the other lawyer's time, it wastes the other client's time, it wastes the court's time. So that's one of those kind of unforeseen consequences. We talked about the process that's involved in unbundling your legal services. And I started the conversation by saying, I've been a lawyer for 25 years, I used to provide unbundled legal services all the time. I won't anymore because there's a very strict obligation on me now to sit down with that client, explain what unbundled legal services are, make sure the client has the mental acuity to understand the nature of the unbundled legal services as opposed to a retainer, then document that in a written document. And as we all know as lawyers, you can have a conversation with someone in about 10 minutes, and if you have to explain all that in a written document, you're spending an hour. Then you got to give it to the client who doesn't like a 2-page, 8.5 by 14 long contract to sign for what they thought was going to be the simple advice that you're going to give them. So some, we felt, of the rules that have been developed just make the task of providing the simplified service or the limited service more complicated. The other thing that we felt was, and it was brought up by somebody else, there are often times when you get a walk-in client who you've never met before, and then you have to go through that process of assessing that client and what they understand and what's going on. You have to do a lot more field work. Whereas if you've got a client you've dealt with repeatedly, and lots of us do in small towns, that client comes in for unbundled legal services, you know them. You know what's been going on, especially with family. It was pointed out they often come back a year later or 2 years later or 3 years later to review access or whatever it is. The lawyer should be allowed to be a professional in those circumstances and assess the need themselves as to what's required by way of documentation, as opposed to having what I understand to be a fairly fixed rule that you're expected to document in a written document that limited scope retainer. Now, I'm taking that from what's on the Law Society website, so hopefully that's correct. So the bottom line is there are, unfortunately, what seems so simple, there are lots of consequences that flow from the whole approach that make it difficult to do it in accordance with the current requirements. So simplification would help.
Thanks, Alden. Thank you.
Oh, there's more comments over here. Oh, I see your hand over there. I'm going to go up here first.
Thank you. We echo most of the same comments, where there's a few that are different, is that it's unclear how unbundling changes the standard by which we're expected to practice. So this is potentially a liability issue, a professional liability issue. It comes back to the lawyer to assess the client, to assess the needs, to assess the likelihood that the client's going to come back and with the right answer, that the client's going to go away with the right answer, that you've documented your file, that you've reported your file, all of those things. It doesn't seem that unbundling has really had much testing in the context of professional liability. So there's a significant risk at the outset on how lawyers would take care of managing that risk. initially. There is a significant question that unbundling, as a rule, is geared towards one or two types of practice. It was a concern around the table about, conceptually it might be okay for a criminal practice, but in most cases in the criminal practice it may be absolutely terrifying to unbundle those types of services. There's no predictability that your coaching would result in in the client actually executing that, and only months later realizing that it went completely wrong, and now it's their word against yours, and you know how that works. The unbundling will also contribute to a problem with the administration of justice. It doesn't resolve the issue of unrepresented litigants attending before the judges. So notwithstanding that there was coaching involved to get to the courtroom, while they're at the courtroom, the judge is still now a participant in coaching this unrepresented litigant. So while you may be doing a service to the client, you potentially may still be contributing to the disservice to the administration of justice. And one last item is I'm a real estate practitioner. It seems that I have got the opposite problem. In many cases, there was a recent rule about disclosure of fees, and you'll see that the opposite is now true. So the fee that I provide can't be a total fee if it's going to be disclosed that way. So now I'm bundling my services and disclosing the bundled service, whereas there's a lot of real estate lawyers that would say, this is the fee, and then after the fact, but there's another fee for a discharge, there's another fee for an application, there's another fee for this, and then at the end of the day, the account becomes astronomical. So the real estate context is quite a bit different, I think, even as well.
Thank you. Somebody had their hand up over on this side.
Just one comment I heard from our group was whether there was going to be feedback from the judiciary on their perspectives of unbundling and how it affects their courts.
Are there more comments before that? So just, I mean, it has been a real push in a number of conversations, and Tammy does talk a lot about the importance of this being done well and educating the judiciary, right? And we'll talk more about that. The interesting thing from some of the tables, I hear some do and some don't, but I hear a lot of concern about it, which I knew there are concerns, lots though of concerns. I'm wondering, could I just get a show of hands of people in the room that actually provide unbundled legal services? So a few, not a ton, but there are a few, right? So maybe we should do a mini focus group with you and figure out how to bridge some of the issues. So I'm not sure I can answer fully on the judiciary because we can't really speak for them, but I know that they work hard to try and find some help for the unrepresented folks, and that this is a way that they see as providing some a la carte services. So obviously, if it's not translating and you're having to provide the full service for the a la carte price, not so easy. I'm just looking at the time, though. Was there anything else on that? Of course, obviously, we have to do this again with the other two questions now, and we don't have the time to do it. I'm not sure if we should try and do a little bit of a survey through FOLA or something like that on our other questions. We can try and do that, but I know this has been helpful. Cara, is there anything? Pardon?
A survey? Anybody? A survey monkey. Yes, I think we could manage
Katie,
a survey
you can do that for us, yeah?
I just, maybe just a quick show of hands. Would people be interested in participating in a oh, hi.
One of the issues of
I think one of the concerns at our table, because our table was pretty much universally not in favor of unbundled services. And the question was raised, are you going to get feedback from the judiciary on this issue? And for us, we're wondering, what is the source of the need for unbundled services? Is it because you've discovered that, the clients, they just don't want to pay lawyers? And are they the people that can afford lawyers, or does it go back to earlier concerns about legal aid not being funded? Because I am in the criminal courts all the time, and we are definitely seeing an uptick in the number of unrepresented individuals, and it's a huge concern for the judiciary, and usually it's as a result that they can't get legal aid to cover their services. So I'm just concerned that this is a way to download this problem onto the shoulders of the lawyers, when in fact it's an issue for that legal aid is underfunded.
Well, I mean, hey, we all agree with that, right? And I know Jane and Terry and others have sat on the Alliance for Sustainable Legal Aid, and we are constantly looking for better funding and better mechanisms. I mean, when you look at family, though, I mean, you can't really even get legal aid for family, so it's a bit tough. And part of the driving force of this is they talk about 70% in some of the Ontario Court of Justice courts and family court are unrepresented. So it's partially driven by a gap that there are no services, and I think the judiciary is keen to have some help in that regard. As I say, I can't speak for the judiciary, but your point is well taken. One thing I would say, though, we did do some survey work with the public, and it is, I mean, like everything else with the public, they are looking for more and more of this kind of service across the board. So partly, when the public wants a particular kind of service, you do have to start to address how you're going to do that, because that will drive change in ways that you can't control. And so let's maybe make sure that we have something that is going to work for the profession, for the judiciary, and for the public. I don't know if you want to say anything.
And it was the last piece, and I forgot to mention it, but one of the things we kicked around on our table was how about if the Law Society would actually construct the limited retainer document that would go with unbundled. Save us
I can't reply. I did write that down, that would be of assistance. And I know that we did do a number of workshops on unbundled legal services. So that's something we can take back and think about, A, why we're not, and there may be good reasons for that, and B, what tips or help that we maybe can give. So,
Yep.
Cara?
Yeah. No, I agree with that. We did, I think we both wrote it down. We both took it as a takeaway for something that we need to look at. So I think we'll leave our next two questions maybe for the next plenary with a few other questions. But thank you very much. Thank you very much for participating in this, sharing your ideas. It was a big help to us. Thank you.
Thanks.
Right.